The judge took it as an undisputed fact that the construction of new single-family homes has been abolished in Minneapolis, which is not true at all. A lot of tabloidy clickbait headlines have said that, and just lazy headlines have said that. You can absolutely build single-family homes in Minneapolis right now. What we have done is allowed the construction of triplexes in low-density, formerly single-family exclusive areas. So it's kind of alarming to me as a normal person who wants to put his faith in the system, that somebody who's become a judge can get a really basic fact like that wrong, and it makes me question what else has he gotten wrong. But I don't want to be naive here. People make mistakes. But it seems like a big one to make when the zoning code is the issue.
We're rolling. We're rolling.
This is a real thing. Real thing.
None of you have the balls to stop this. Stop this.
I've got plenty of time. I have nothing else going on today.
We're in the Wedge neighborhood right now.
This is the Wedge Live podcast. I'm your host, John Edwards, and today we're going to talk about the recent 2040 plan lawsuit. The city recently lost in district court after an appeals process that took place before that, and today I'm going to talk with Matthew Melewski, who is a lawyer who has experience with land use issues and Minnesota environmental law. Matthew, welcome to the show.
Thanks, John, for having me.
And is there anything you would like to add to your bio? You're not working on anything related to this case, right? You're not a party to the case. Anything else about your experience?
I'm not a party to the case. I was very interested in it for a number of reasons we're going to talk about later. I used to live in the origin of this lawsuit, Ward 13, and was very interested in it for that reason as well.
And you and I have been conversing over email for many years. It's almost half a decade. You and I have been emailing back and forth about the various lawsuit and the appeals and the Supreme Court. Every time something new happens, I email you. I'm like, tell me what this means.
It's really interesting. There's a number of very interesting twists and turns and complications from this.
I'm going to start with a little bit of background. I don't think our audience needs a ton of background on the 2040 plan, but most famously, it did away with single-family zoning, which is the headline result of it. It turns out we're getting 75-ish units per year related to the single-family zoning repeal. So that's, I think, Alex Schieferdecker and Street Cement pointed out, that's the equivalent of a medium-sized apartment building. So the impacts in that regard, it feels like, and I'm jumping way ahead here, but it feels like we have some results of this that the judge could maybe look at and say, well, that argument seems wrong because we have multiple years of results here to disprove it. Am I off base there? Or is that something a judge can't look at?
It's really complicated at this point because Mira is generally used as a means of stopping something from happening. And here the judge is in the middle of this summary judgment determination, several years after it's gone forward. And we have some results. I don't know that the plaintiffs ever changed what they were requesting. In theory, a Mira claim can be for past harm, but I think what they were requesting was simply forward-looking to prevent future developments. So the judge could have. I don't know that it's particularly relevant to how he ruled on the case.
Okay. And I'll get back into describing what the plan is. So there's some significant upzoning of transit and commercial corridors, called for eliminating parking minimums, which has since happened. legalizing single room occupancy, which has also happened, and the county has used it to build some housing targeted at getting people out of homelessness. Here's language from the plan. Undo barriers and overcome inequities created by a history of policies in our city that have prevented equitable access to housing, jobs, and investments. So there's transportation parts of the plan, housing, jobs, all these things interrelated. And 2040 plan is also a precursor to the city's ambitious transportation action plan. And I'm going to jump ahead again. Is the judge looking at like all pieces of the plan together, or just the impacts of the upzoning and the housing stuff? Like, is the judge saying, well, they're upzoning, adding all this density, but they've also got a transportation piece that will mitigate the traffic impacts? Is that something to be considered or no?
That's part of the problem in the judge's decision, and I think how the city has responded to the lawsuit, or at least the most recent iteration, the most recent decision in district court, in that the plaintiffs just put forward this expert report. It's the same expert report that they put forward when they sought a TRO. It's hastily put together. It's conclusory. It doesn't really provide any information at all. It just says, essentially, if you add a lot of people, there's going to be a lot of other stuff that happens, which is sort of a no-brainer, completely, useless. But they thought, and probably correctly, that that is sufficient to demonstrate the bare minimum to establish a Mira claim. That you show that there's going to be some impact on the environment from the actions of whoever you're suing. And that's it. So that's the focus of everything. There isn't anything else in the record to talk about. What the 2040 plan might also authorize to deal with those things. The city didn't offer any rebuttal to that plan, so there's nothing that says, yeah, when those things happen, we'll change these other elements of city infrastructure. So there isn't anything else to really talk about.
So was the city just overconfident in thinking, well, this fully built out thing is so ridiculous, it's such a weak argument, we're going to rest on the idea that that is stupid and the judge will toss it and we won't bother with rebutting the environmental stuff? Where did the city go wrong in defending it?
I haven't seen all the filings that took place in the district court since it was remanded from the Supreme Court. So it's possible the city tried to do what I'm about to explain, but what they should have done, in my view, is sought a determination on whether or not the plaintiffs can assume a full build-out for purposes of this stage of the litigation. They should have said, first, judge, determine whether or not they can do that. Because if they can't do that, everything else we're talking about is completely moot. And if they can do that, that's the first time anybody's ever, said anything like that under Mira. As far as I can tell, as far as, every other court case I've read about this suggests, nobody's ever made that sort of leap to those sorts of assumptions. So they should have, and maybe they tried to do this and the judge said no, but there's no reference to it anywhere.
So I was so excited about this conversation that I jumped far ahead, and now we can go way back to the beginning, and we can explain what Mira is, what is the premise of the lawsuit, who is suing. I call them pretend environmentalists. One of them is Smart Growth Minneapolis, which I think was created just to do the lawsuit. The Audubon chapter of Minneapolis, Minnesota Citizens for the Protection of Migratory Birds. I'll tell a funny story about the Smart Growth Minneapolis people. One of them is like a famous personal injury lawyer who, and so if you can recall back to the 2040 plan debate, everyone had a yard sign that said, "Don't bulldoze our neighborhoods." And the personal injury lawyer, who is one of the rich guys behind this lawsuit, lived at the time the lawsuit started. I don't know where he lives now, in a house that he built after bulldozing the previous house. So those are the kinds of folks who are behind this lawsuit. And so let's get into Mira. And I remember you being very skeptical. There's an exemption for comp plans in Minnesota environmental law, I think a different environmental law. Can you just discuss all of those things.
Yeah, no, I'd be happy to. I do have to remark on the personalities involved in this lawsuit. I mean, in addition to what you just said, you have the primary lawyer of this environmental protection lawsuit who permits landfills. I mean, proudly has explained to the court that he's probably permitted more landfills in the state of Minnesota than anyone else. That's what he does. And you have added to the appeals a lawyer who probably is known to many people in the state of Minnesota is Nikemi Levy-Pounds, who used to be a law professor at St. Thomas, was briefly the head of the NAACP in Minnesota, and has been an overall, gadfly in Minneapolis politics, certainly for a while. And she's added as an appellant attorney. So you think, well, she must have, extensive experience in appellate law in Minnesota. No, she's never really done this at all. Well, she's an environmental attorney. She's that's what she did when she was a professor. No, she has no experience as far as I can tell whatsoever. So then the question is, well, why have you added her as an appellant attorney?
Right.
And the really depressing answer I come up with is the people who started this lawsuit are self-aware enough to know that there are a bunch of rich white people in Ward 13 trying to dishonestly claim that this is about the environment. And in order to rebut the very clear fact that the Minneapolis 2040 plan is intended to, eliminate the inequities in the history of redlining in Minneapolis, they've added a very prominent black attorney to their team.
Yeah, that's the correct answer. You're correct about that. That's not your opinion. That's a fact.
So, there's just a load of, unbelievable characters involved in this. So to your question about Mira and MIPA and what those things are, Mira is somewhat unique. Not a lot of states have an environmental law like this. It's the Minnesota Environmental Rights Act, and it basically says anybody can sue anyone else to prevent some demonstrated destruction to the environment. That's basically the simplest version. You can initiate a lawsuit in order to do that, a private lawsuit. And that's pretty dramatic if you think about it. I mean, you could use that in all sorts of ways, positive and pernicious. About 2 years after that, the state legislature passed MIPA, which is very similar to a federal analog called NEPA, the National Environmental Policy Act. And MIPA is the Minnesota Environmental Policy Act. And that's more procedural environmental statute. It says, what do governments, any aspect of a government, what do they have to do in order to take certain actions with respect to the environmental considerations of those actions? So if you want to, authorize building some series of homes, what sort of environmental study do you have to do in order to build those homes? And the legislature, as often is the case, leaves the specifics to the agency that is authorized to write the rules around how many homes and what sort of environmental impacts and what sort of timelines and that sort of thing. So you have, after MIPA is passed, the state agency, I think it's the EQB, writes these rules that say these sorts of things, when a state agency or local government does them, they require this level of environmental review. These other things require this level of environmental review, and these other things are exempt altogether. And that's the basic sort of legislative and administrative framework for what we're talking about.
And so it's the case that MIPA exempts comp plans. Do I have that correct?
Yeah. So the MIPA regulations, the ones that are passed, not the law itself, but the regulations that were passed by the state agency to implement MIPA, say comp plans are exempt. Comp plans are exempt from having to perform the most stringent of those, which is environmental impact study, and then the lesser stringent one, which is an EAW. They're just exempt altogether, as is just generalized zoning changes. Zoning changes are also exempt.
And so it's pretty extraordinary to now, which is something I've heard from you, to now say that things like zoning and comp plans are now subject to Mira, right? That's a new thing that we're aware of, based on, is it the Supreme Court who has now said that?
I think that due to a couple things that the Supreme Court said and a couple things that the district court judge said, that is going to be the perception of what the Supreme Court has done, but I don't think that's not actually what they've done. And what they've done is actually much narrower. And I'm hopeful that when this goes back to the Supreme Court, because that's likely what's going to happen, they will realize the error of their dicta, which is things that they wrote down that had really nothing to do with the holding but created confusion. And they will make it clear that you can't actually do that. But a comp plan has never been subject to Mira anywhere in the state. Nothing like a planning document like this has ever been. And the courts have made clear for 50 years that Mira doesn't operate as an end run around something that is specifically exempted under MIPA, or where the governmental agency complied with MIPA, whether they were required to do a certain amount of environmental review or not. You don't get a second bite at the apple under Mira. That's not how it works. These laws are supposed to work in tandem.
So the first time around, the district court judge tosses it. Was it also tossed out in appeals court before getting to the Supreme Court the first time?
Yeah, so the first time around, the district court judge says, very reasonably, I mean, this is what I expected to happen. There's a implementing regulations of a state statute say comp plans are not, plans like this are not subject to review. So the relief you're requesting, making this subject to review, is just not, it's not there. So you don't have a claim. And also you can't assume that there's a build out of the entire 2040 plan. That's too speculative. You have no basis for that. So even if you could bring a claim, you fail on the ground of assuming the full build out. And the Court of Appeals said the same thing. So exactly the same thing. There's a specific exemption here, and also you can't assume a full build out. There was one concurring judge, the Court of Appeals, that said, yeah, you can't assume a full build out, but I'm not so sure about how you interpret the regulations and the law here. I think maybe Mira and MIPA are a little more complicated than that, and it's possible that a lawsuit could proceed under Mira even though MIPA exempted the activity at issue. And that turned out to be somewhat prescient because that's ultimately what the Supreme Court relied on.
And so now it's back with the same judge with a different result based on what the Supreme Court has instructed this judge to do, basically? Is that the scenario we're in before this judge gives us a ruling saying the city is in the wrong?
So the Supreme Court says, they decide that even though MIPA was passed after Mira, that because it's a regulation that specifically exempts the plans from review, those don't overcome the general Mira right to sue anybody for any environmental harm. You can still have a Mira claim anyway, is what they say. There's some their reasoning on that point is not really terribly dubious, but it's also not very convincing. You could easily go either way. But what they say with respect to the full build out of the plan is they say, for purposes of a motion to dismiss, this is really the crux of this, which is like sort of the legal aspect of this. When you're in a motion to dismiss, the state, the apparatus of providing justice, says all you have to do is say these things are true, and you survive this motion to dismiss stage. Because if the defendant moves to dismiss, you don't even get your day in court. So we will assume that everything you say is true at the very beginning. We're just going to assume everything is true. So what the Supreme Court said was, they say a full build out is going to do this, we're just going to assume all that's true. We're not going to question any of that because the stage of the litigation is a motion to dismiss. So we'll assume it's all true, and then you get to move, to the next stage of actually like proving it. The district court went a whole other step further and did a number of different things. Took discovery on the issue, compared expert reports, and then decided at the same time that you could do a full build out. And that his decision as to why you can assume a full build out of the plan is really, I think completely unsupportable. And I assume the city will appeal that.
Yeah. I mean, I could see why he's maybe frustrated that they didn't rebut the environmental stuff and they just presented a real estate analysis, like a market analysis of population growth. But I assume the reason the city presented that population growth and market related stuff is to say the full build out argument is wrong.
I assume that the city just doesn't want to concede that there is a claim here under Mira at all. That you simply, for a planning document like this, you don't have a Mira claim. And that's really, the thrust of the judge's decision is twofold, really. One, well, if not now, when can you challenge a plan like this under Mira? Shouldn't it be now? Because later it's more complicated and harder, so it must be now. And he never once stops and thinks, why do you have to be able to challenge it under Mira? Isn't this just something that inherently is too speculative to be able to be challenged under Mira? To my mind, that's the correct answer that the Supreme Court will issue in 2 appeals later in 18 months. The other thing that...
Two appeals later. So
he's
appeals court and then back
correct.
to the Supreme. That's what you mean by
it's
two
appeals. It's going to go to the appeals court.
So
the
18 months. That's probably like 2024, right?
Yeah, then Smart Growth will have spent about $450,000, I would guess, at that point.
Are they paying for this, or is an interested lawyer donating his time? Is Jack Perry just like a really big fan of fighting this?
I'm sure they're paying almost full freight. Maybe they're going to get a 10% bit off the top.
Seems like a tremendous waste of money because I assume they all live in like R1 areas. And as I said at the beginning of the show, only 75-ish units per year in 2 to 4 unit buildings have been built on an annual basis since the low density zoning changes have been made. So like what they're getting for their $450,000 is not great. Or I don't know. Maybe I shouldn't ask you to get into the psychology of these people, but you're just a lawyer. Like, what are they just like emotionally attached to this? Seems like a whole lot of harm they're ready to do for not much benefit to themselves.
I mean, frankly, you mentioned the signage that went around at the outset of this. It all seems very much part of Richard Hofstadter's paranoid streak in American politics. People assuming some sort of nefarious intent and outcome and some sort of horrible thing's going to happen because of some change that is foreign to them or impacts them for the first time in their lives. And you see that reflected in the judge's most recent opinion, where he says at one point they're going to, never before has a comprehensive plan authorized the destruction of single family homes, which is just bizarre. That's we're going to bulldoze our homes. It's the same sentiment.
The judge took it as an undisputed fact that the construction of new single-family homes has been abolished in Minneapolis, which is not true at all. A lot of like tabloidy clickbait headlines have said that, and just lazy headlines have said that. You can absolutely build single-family homes in Minneapolis right now. What we have done is allowed the construction of triplexes in low-density, formerly single-family exclusive areas. So it's kind of alarming to me as like a normal person who wants to put his faith in the system, that somebody who's become a judge can get a really basic fact like that wrong, and it makes me question what else has he gotten wrong. But I don't want to be naive here. People make mistakes. It seems like a big one to make when like the zoning code is the issue.
Yeah, no, it's a thoroughly embarrassing, clear factual error that goes to the heart of this entire dispute, which really, really is hard to understand when this has been ongoing for 4 years now, to make that sort of mistake at this point.
We'll be right back after a brief message from our sponsor.
Hey listeners, I want to talk to you about fashion. Did you know that Wedge Live has t-shirts and hats available? I'm wearing some right now. If you already have your Wedge Live merch and need even more creative shirts from around town, grab the latest issue of Dispatch. For this month's issue, Dispatch lays out some fashionable local shirt recommendations for your summer style. Plus, they check in with Mary Lucia, preview the upcoming Afropunk Festival, unpack the insane memes of the Walker Teens Instagram, and much more. And you know I love some insane memes. Sign up for their newsletter and get more reports from the Minneapolis and St. Paul arts and culture scene at dispatchmsp.com. That's dispatchmsp.com. What does the city do next? Is this district court judge done with it at this point? Is the appeal next? What is the next step that the city takes?
I can't imagine the city won't appeal. I assume the city will simply appeal to the Court of Appeals. The city's appeal will probably be focused on the argument that you can't assume a full build-out for purposes of Mira. So you can assume a full build-out for purposes of a motion to dismiss, but not the substantive Mira claim. Once you make it past the motion to dismiss, and the plaintiff has the burden of demonstrating some actual harm to the environment, you can't assume what's going to happen in the future. Speculative impacts is very, very clear in 50 years of Mira cases. Speculative impacts don't count. And the judge here simply said, well, if that's true, then you can't bring a Mira claim against a plan like this, so that you must be able to bring a claim now. And he also said, and this is the really sort of dubious part of the opinion, well, the Supreme Court has said, if you look at other Mira cases, they use language that's like, well, the planned thing or, the authorized development. And so this is no more different than that. And he's really sort of comparing apples to oranges here. What he's talking about is in documents like a conditional use permit that authorize the building of a building, or a specific zoning change that specifically authorizes the construction of a road. You have an actual tangible project there. You have the width of the road, and you have all the ancillary pieces of the road that control drainage and all the things you're going to have to knock down to build it. And the house is, there's a square footage, there's a whole plan, there's a blueprint, there's a number of people that are going to be in it. So it really, that's a sort of, not very convincing argument that I think the city's going to probably be successful appealing that to the Court of Appeals, saying, this was fine for a motion to dismiss, but once you get to the substantive claim, you simply can't speculate like that. That's not how this works.
I want to briefly, for the audience, explain why assuming a full build-out is dumb. And maybe this doesn't matter in court, but under the old comp plan, the 2030 comp plan, so the plan adopted in the 2010 era, produced a zoning code not much changed from the ones before. And so, for example, using the Wedge neighborhood, you could build 6-story apartment buildings where there were single-family homes and duplexes and triplexes, but for decades, that did not happen. Just because you're allowed to do something doesn't mean that it happens in every place where it's allowed. It doesn't. That doesn't happen.
Yeah, no, I think that's absolutely right. I mean, one of the linchpins that the judge has held on to, the plaintiffs have championed, and I think it appears in the Supreme Court case, is the fact that there is a legal decision. A judge said at some point, that zoning can't conflict with the comp plan, and if it does, the comp plan wins. And that's sort of judge-made law, but that's the law in Minnesota. The comp plan wins. And so that's been interpreted as, in this case, as meaning that everything is now, ground under the heel of the plan. The plan dictates all, and what the plan says happens. And as you said, that's not how any of this works. The plan is really authorizing these things. The plan doesn't have the funding to build it out. It doesn't even contemplate how this all happens.
Right.
It's simply authorizing it's authorizing changes to the zoning code that will then in turn authorize the construction of things that have yet to be even, remotely penciled out.
I mean, we're all legally authorized to drive our cars at the same time on Lyndale Avenue between Lake Street and Franklin Avenue if we wanted to, cause a great big traffic jam and lots of emissions, but we don't. We're all authorized to flush our toilets at the same time and see what happens, but we don't. There's lots of examples of things like this. So is the city allowed to change its argument going forward and respond to criticisms of the district court judge? How does that work? Can they say, okay, the judge found this to be a weak spot in our argument? Are they allowed to? Are they likely to change it and do the environmental assessment? Because personally, as someone who believes this is a good thing for the environment and fighting climate change, creating dense pedestrianized cities that can support transit, I think that's a win for the environment. I think climate scientists agree with me and have said these things. So is that allowed to be an argument moving forward? Is the city likely to start making arguments like this?
I don't think so. And I don't think so because the reason comp plans are exempted and the reason the city didn't do an environmental assessment or environmental study of the plan is not simply because they're allowed to skip that step in the process. It's because comprehensive plans are so speculative that figuring out what the environmental impacts actually are is a fool's game. You really have no idea what is going to actually happen or when. And that's the reason the city didn't do it. And that's the reason the city probably won't. They can't. It's not something you're taking one speculative plan and adding one speculative environmental impact assessment. It's not useful in any way.
So has the city made mistakes, you think? Did the judge make any criticisms of the city's argument where you're like, yeah, I can see how the city did the wrong thing here? Are there things for the city to fix, or are we just hoping for the next judge to look, or series of judges to look differently on the arguments?
As I said before, if the city didn't try to do this, they should have tried to peel out assuming the full build-out piece and just had the judge rule on that first. If they didn't try to do that, they should have done it. As I said, I can't say that they didn't, and the judge didn't, in an oral hearing, just say, no, we're not going to do that, move on. The opinion also alludes to the judge, or the city saying that they were going to seek a hearing to disqualify the plaintiff's expert as an expert on this issue. And the judge, in the opinion, says he made time, he changed the briefing schedule for that, and then the city never did it, which it doesn't sound very good. But apparently they never did anything. As I said, I don't know how they would file an environmental claim, but this was about challenging the sufficiency of the plaintiff's environmental expert.
So earlier you said 18 months until it gets back to. Is that for a Supreme Court decision or for arguments in front of the court, like a general timeline?
Well, you appeal to the Court of Appeals. You're looking at 3 months to get a briefing schedule set, and then 3 months at least after that to get a hearing set. And then the Court of Appeals by law has to issue an opinion within 90 days, so 3 months after that. So you're 9 months out from a Court of Appeals opinion, and about the same for a Supreme Court opinion.
Okay. And how likely is the Supreme Court to just not, because the state Supreme Court can also decide not to take a case. Would they do that? Or
I think if the city is effective at framing the implications of this, that this means that, comp plans don't work anymore because somebody who's opposed to them can simply challenge them under Mira with their own speculative fly-by-night expert analysis, that, and challenge it, it's really hard to get away from the fact that these people are using this in bad faith. These are not people who care about the environmental impacts of this. It's like blaringly obvious. So that can happen in every case, in every city. Every planning document of this type in municipal government is now able to be stifled under Mira, even though all of the impacts that are possible are speculative, which is something that the Supreme Court has said for 50 years is not okay. I think if the city is able to effectively frame it in that way, the Court of Appeals is going to say, no, you can't assume a full build-out. We've already said that before. The Supreme Court didn't really opine on that. They were just talking about the standards, the burden under a motion to dismiss. And the Supreme Court, I hope, will see, yeah, that's a pretty significant issue. We should probably, finally resolve that. What is absolutely required under Mira to make a claim out.
So in the district court judge's decision, he made a lot about how this comp plan talks about population growth and promoting it. And I kind of interpreted the plan as anticipating and planning for like an inevitability. Previous comp plans may not have been as specific about population growth estimates as this one, but our population still grew by like 50,000 in the last 10 years. And so it just seems like something you should plan for. So, I guess my question is, if the city had left the population stuff with the same plan, same zoning, same built form guidelines, all that had been the same, but left out all the talk about population, would the judge have been able to make the same decision?
I don't know. It's really hard to say. You're right to focus on that, though. It is very strange to read it, and because the judge emphasizes over and over, well, never has a comp plan before authorized this sort of population growth, and you think to yourself, okay, well, nothing the city can do, including this plan and otherwise, actually forces people into the city. So, what are you talking about? And also, the previous plans didn't say it, but it grew by tens of thousands of people anyway. So, what is the point of this? I'm completely lost as to why the judge thinks that that's meaningful in any way. And I think if they'd not done that, they would have just found some other reason.
Okay. Last question, which you may not be able to answer as a lawyer who goes before judges and has to be nice to them, but politics. I'm a believer that courtrooms are political places and judges are political actors. Am I right about that?
Yes, absolutely.
Because I interviewed a series of candidates for county attorney, and there was one candidate who was like, we're just here following the law. And I'm like, you're running for office, and you may have rejected the idea of seeking party endorsements, but you're taking political actions here in courtrooms every day. And so I wonder about land use issues in particular. And we talked about the mistake that the judge made about the idea that new single-family housing had been abolished. That was not true. I just wonder if there's something about the class of person who becomes a judge, the age, the income level, the education level, probably lives in a single-family neighborhood in Southwest Minneapolis or places like that, who is just kind of repulsed in the same way that people who brought this lawsuit by the idea of, well, a triplex next door. I don't know about that. I'll lose my privacy. Those renters will be very loud. I just wonder, you could probably say this about a lot of different kinds of cases, not just land use, but something about the class of person who is a judge who just makes it difficult, more difficult than it should be, more difficult than maybe the law would have it.
Yeah. I think your initial assessment is right as to the extent I'm willing to sort of opine on that. But I will say, sort of from a structuralist sort of point of view, judges are people like everyone else and subject to the same sorts of flaws and vanities and errors of self-assessment as everyone else. And they also are, in our society, distributed like everyone else, which is to say, white men are wildly more frequently to be in positions of power. And even though I would say judges are much more likely to be people that are public-minded and civic-minded and interested in the well-being of our society, that doesn't mean that they're not overwhelmingly old white men, and subject to all of the socio-political influences of old white men in America. So it's not so much that I think that they have particular interests. I think the problem is when you deny that they are subject to all of those influences, like anyone else. You know, John Roberts went before Congress when he was being appointed to the Supreme Court and described his job as just calling balls and strikes. And that is just a lie. That is a bald-faced lie. He knew it. Everybody else who's any sort of sophisticated lawyer knows it. That's not how this works. That's not how it works at all. I mean, in this country, we have something called a common law system, which means that a huge chunk of the law is literally made up by judges. They make it up. They just decide this is the law now. It wasn't yesterday, but it is today. And if you make up the law, you dictate literally the political landscape of our society. So, pretending it's not true is the problem.
This has been a really good discussion. I feel like you made me think of some things I hadn't thought of before, and we got to talk about them. Am I missing anything from this? Anything that could be very interesting to people who are not following this closely that I just have not prompted you to start talking about?
I mean, just in the terms of Minneapolis politics, I mean, this is just one of several sort of rearguard actions by Ward 13 to simply, try to reassume control over the city's politics in a way that is, inimical to, frankly, democratic self-governance.
I agree, along with this whole strong mayor thing. Do you have any opinions about that? You're a lawyer. Maybe you have opinions about our city charter. Or no?
Not so much. I do find it very difficult to listen to the mayor talk about what's going to happen in the future. Now that he's got additional powers, when he was, in fully control of the police department ever since he became mayor.
So again, this has been wonderful, and we got through it in 41 minutes. I can't believe it. I was so excited to have this conversation. I don't know how we did it in 41 minutes. I think people will love it. Matthew Melewski has been my guest. Thank you for joining me.
John, thanks for having me.
And I'm your host, John Edwards. This has been the Wedge Live podcast. Thank you for listening.
This is a real thing. Real thing.
None of you have the balls to stop this. Stop this.
I've got plenty of time. I have nothing else going on today.
We're in the Wedge neighborhood right now.